Yeah, welcome to this guest webinar. That welcome our Subhan Bandes, a keynote speaker, and he's an advocate, and Kadapa, Andhra Pradesh, India. And I put it on the screen regarding the details are concerned. And let me give you a light introduction about our keynote speaker. As I said, he's a practicing advocate. But one thing is very much impressed me, which I told in the last time also. Sir is a LLM from Acharya Nagarjuna University and LLB from the Kadapa, from the local college. The local college here, what I mean, the Vemana. Is it not Vemana? Yes, yes. I think that the same uh, Vemana College, if I not be mistaken, let me say it that yes, no Yogi, yes, from Yogi Vemana University, Kadapa, and sir is UGC net in the both LLM and UGC net also qualified in the business administration HR industrial relations. Sir is actually the Bachelor of Science from Sri Venkateswara University, and from science background, the sir has shifted to the other area. That experience is there, advocate. In 2014, sir has made it, and he is a standing counsel for the many other insurance companies, and he practiced both the civil and the criminal side. And the subject he has made several videos on the law of crimes to evidence civil procedure, law of contract, law of transfer of property, law on negotiable instrument, law of Torts and Consumer Protection Act, and the law of specific relief, and go on law of registration, and many other things goes over there, including the Right to Information Act plus human rights, not forgetting the Muslim law and Hindu law also that he made some. And sir reviewer is there, International Journal of Business Research and Development, and is Ottawa, that Canada, the reviewers are there. And sir is membership in many other professional organizations and societies like International Economic Development Research Center, International Association of the Academicians and Researcher, Asia Pacific region Singapore, and International Association of the Computer Science and Information Technology Singapore, and guest lecturer has given many other things, many other subjects, rather we can say the Indian Penal Code, evidence, CPC, Limitation Act, Transfer Property Act, Registration Act, Marriage and Divorce laws and succession laws, Hindu and Muslim laws and human rights, go on so forth. He has made the many other procedure aspect of also the he has given the delivered the lecture for the civil courts in various educational institution as well as the APP and JCJ also. So community service sir, is very much attached with the legal literacy camps organized by the district service authority, that is a cell in Kadapa. Then the publications are concerned, say a number of publications, 4, and presentation conference 15, workshops attended 3, faculty development program is 2, the webinars attended is 97. So sir has attended the many webinars, and the range is 97, and that is regarding the nutshell about our keynote speaker. So let me see that what are the response of the participants. Let me see it. Yes, participants are joining one after another. Okay, no matter, sir, because if one person also benefited by our lecture, that is our mission is our mission is fulfilled. That is our things. So we cannot become a king now. At least we want to become a kingmakers. So that is the our efforts are there, including the Subhan Bandes are also. If he wants, he can go for the teaching, but he said better I will be go for the practice. Then I will do the render the services to the masses as well as the society. In that way, that sir has made it. And with this time of the thing, I would like to stop my thing. But before I could go over there, as a traditional things are there, then we will play the Janagana Mana. Then I will hand over the my mic to the sir. So please, better we start the Janagana Mana. So everybody should stand over there. Then we will listen.
अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंधु गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उज्जल जलधि तरंगा तव शुभ नाम
भारत भाग्य दाता जय हे जय हे जय हे जय 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 Jai Hind. Yes, with this that I would like to make it a stop my thing. Then I will switch over to our sir. Then I will make this thing that I will make it. Yeah, I will synchronize it. Then I will remove this one so that sir will be there to take care of it. Yes, sir. I'm coming to your point, sir, and I will hand over the things to you now, sir. Now you can start your lecture, sir. You can make your presentation, sir. And I'll switch over to the Advocate Subhan Binde, sir. Please continue your lecture, sir.
Thank you, sir. Thank you for your kind words.
Yes, sir.
The topic for today's lecture is inheritance rights of women, a comparative analysis of Hindu and Muslim laws. My today's lecture will be on the inheritance rights of Hindus and the inheritance rights of women among the Muslims. The part one of my lecture is related to the inheritance rights of women as per Hindu law. The second part is related to the inheritance rights of women in Muslim law. Friends, let us know the concept of inheritance among women as per Hindu laws. The concept starts with the evolution of the concept of inheritance. Generally, there are two modes of inheritance: testamentary inheritance and non-testamentary inheritance. If a person dies by making a will, simply, if a person dies after leaving a will, it is said to be a testamentary succession or testamentary inheritance. The study of law related to how the property of a deceased person goes to his legal heirs in case of if he dies without making a will is related to the concept of succession, the concept of intestate succession or intestate inheritance. Friends, first we need to know the evolution of inheritance rights of Hindu women. As per World Economic Forum 2017's report, women throughout the world own less than 20% of the world's land. It says that just 20% of the land is owned by women. Rest of 80% of the land throughout the world is owned by the males, men. Now, let us come to our actual topic, the evolution of inheritance rights of women in Hinduism. There are certain traditional laws before codifying the Hindu law through Hindu Succession Act 1956. There are different sastras, commentaries, and digests which decided on the inheritance issues among Hindu males and females. According to Dharma Sastra, it's the duty of the woman to provide that the safety and security to children, the world, and the infirm persons in the family, and the other such members of the family are not at all related to these domestic works. Women are confined to the domestic work according to some other sastras. If a woman was given absolute freedom, then they will neglect their marital obligations, their domestic works, and the management of household affairs. That is the reason why women were not conferred with the absolute rights over the property. This was a interpretation of inheritance rights of Hindu women as per certain shastras, as detailed by Narada. The transactions of a woman had no validity, especially the gift, hypothecation, or sale of a house or field or any other immovable property. Such transactions were valid only when they were sanctioned by the husband or on failure of the husband by the son. As per this interpretation, it is very clear that the woman, as per the traditional Hindu laws, always depended on either husband or the son. Before she get married, she should depend upon the mercy of her father. There is no independence at all. There is no right to woman to hold some immovable property. As we know, there are two principal schools of Hindu law. They are Mitakshara school and Dayabhaga school. Of these two schools, Mitakshara was considered to be more biased against Hindu women and gave them the least of the rights to inherit the property. Thereafter, the Britishers came. They decided to overhaul the Hindu law and passed many more legislations to reform such biased Hindu laws, shastras, and to provide women with more rights. Through their legislations, they reformed the Hindu law, especially with related to the inheritance rights of women. They have enacted Hindu Widows Remarriages Act in the year 1856. Thereafter, they have enacted the Hindu Inheritance Removal of Disabilities Act 1923, the Hindu Law of Inheritance Amendment Act 1929, the Hindu Women's Rights to Property Act 1937. All these enactments are enacted by then British rulers in order to reform the inheritance rights of Hindu women. But the traditional laws always focus on fulfilling the domestic work, taking care of children, old age persons, and the deceased persons who are in the family. Except in case of fulfilling the indispensable religious and charitable purposes, a woman does not have a right to alienate the immovable property. The limitation is with the respect to the power over its disposal and the inability to transmit the estate even to her own heirs. Otherwise, a Hindu woman had powers just to possess the immovable property and to appropriate the income generated from the immovable property. These are the two powers conferred on Hindu woman as per the Shastras, as per the traditional Hindu laws. There is no power conferred with Hindu woman to hold the immovable property, to own the immovable property as per all the traditional laws. Hence, they are treated as biased laws. Thereafter, after attainment of independence, Government of India has enacted one of the codified law through which a Hindu succession is governed in our country. That is the Hindu Succession Act 1956. The first stage in the evolution of the concept of rights to inheritance rights to Hindu women. This is the second step in this evolution process. Under traditional sources of Hindu law, there is no right, there is no power for Hindu women to own and hold the immovable property. The only exception, as per the traditional Hindu laws, is just to possess it. It confers only the limited powers. We can't say this as a power. Just she can possess some property. She can enjoy some property, but she has no right to alienate the property to third parties, even to her own legal heirs, as per the traditional Hindu laws. The second stage in this evolution process is Hindu Succession Act 1956. According to this act, daughters have no right to inherit the estate of the deceased till 2005. 9/9/2005. Daughters have no right to inherit the estate of the deceased father. Very unfortunate. Thereafter, in the year 2005, Government of India has enacted Hindu Succession Amendment Act 2005. Through this amendment, the daughter of a co-parcener shall by birth become a co-parcener in her own right, the same manner as the son. The Amendment Act 2005, which came into force from 9/9/2005, conferred certain rights to Hindu daughter on par with the son. As per the amendment of 2005 to Hindu Succession Act, a Hindu daughter has got the right as same as the right conferred to the son. This is the third stage in the evolution of the inheritance rights of women as per Hindu law. Next, the fourth stage is the historical judgment of the apex court of this country that was held in Prakash and others versus Phulavati and others. Hence, you can note down the citation. All India Reporter 2016, Supreme Court, page number 769. According to this judgment, daughter should have be alive and her father should also be alive on the date of amendment, that is 9/9/2005. A Hindu daughter gets the title over the co-parcenary property on the basis of fulfillment of certain conditions. These conditions are beyond her control. The first condition is daughter should be alive. The second condition is her father should also be alive. If both the Hindu daughter as well as Hindu father both are alive as on the date of 9/9/2005, then she can entitle her right in the ancestral property. This is the fourth stage in the evolution of inheritance rights of Hindu women. Next, the fifth stage is held. It was upheld in the case, one of the famous cases, Dhanamma alias Suman Surpur versus Amar. It was reported in All India Reporter 2018, Supreme Court, page number 721. In this case, the Supreme Court held that sons and daughters of a co-parcener become co-parceners by virtue of birth, and the partition becomes final only on passing of final decree. The difference between the earlier judgment, that is Prakash versus Phulavati case, and the present Dhanamma versus Amar's case is, in the previous case, the essential condition is the daughter should be alive and father should be alive. Both should be alive. According to the judgment of Supreme Court in Dhanamma versus Amar's case, the essential condition is the father may be living or died, but the daughter should be living as on the date of 2005 amendment, that is 99/2005, daughter should be a living daughter. The father may be a living or died. This is the essential condition. And one more issue is clarified by the Supreme Court of India in this case. That is, there are two stages involved in the partition suits. The partition suits. The first stage is related to preliminary decree. In the preliminary decree, the civil court decides the shares of the parties, both the plaintiffs as well as defendants. It decides the respective shares of the parties. Thereafter, they have to file a final decree petition. In the final decree, the civil court the civil court divides the property on the basis of the good and bad characters of the property, and it gives a separate position after appointing an advocate commissioner. It passes the final decree. This is the second stage involved in any partition suit. According to this judgment, Dhanamma alias Suman Sirpur versus Amar's case, partition becomes final only on passing of a final decree. The male members of a Hindu family filed a suit for partition before the 2005 amendment, that is before 5/5/2009. Then a daughter can implead as a party even after 5/5/2005. The reason behind this one is still there is a preliminary decree and final decree is not yet passed. Hence there is a chance given to the daughter as per Dhanamma versus Amar's case. According to this judgment, partition becomes final only on passing of the final decree. Before passing of the final decree, a daughter who is not shown as a party to the partition suit may implead as one of the parties. Hello, am I able to your sound?
Yes, sir. Yes, sir. We hear you very nicely, sir.
Okay. Then the sixth stage in this evolution of inheritance rights of Hindu women is decided by the Supreme Court in Vinita Sharma versus Rakesh Sharma and others. It was the latest judgment. It has superseded all the previous judgments of the Supreme Court. Now the Supreme Court has given the crystal clear clarity in this case. This judgment was pronounced by the Supreme Court of India on 11th August 2020. It is in the process of reporting in All India Reporter, Andhra, ALD, ALT, etc. Now it is in the process. It was pronounced by the Supreme Court of India on 11/8/2020. This is the latest judgment. In this judgment, the Supreme Court held that since the right in the coparcenary is by birth, it is not necessary that the father and daughter should be living as on 9/9/2005. As per this definition, hello.
Yes, sir. Please continue, sir. Continue, sir. No matter, sir. Continue, sir.
As per this judgment, all essential conditions are removed, completely repealed. The father may be living or deceased as on the date of 9/9/2005. Even the daughter may be living or deceased as on the date of 9/9/2005. These are the essential conditions are fully repealed. As per this judgment, irrespective of the death or liveliness of father or daughter, every daughter has got the right on par with the son, according to Section 6 of Hindu Succession Act 1956. This is the latest judgment. This is the latest stand taken by the Supreme Court. It clarified all the issues related to the concept of succession in relation to Hindu women in our country. According to this point, the amendment of Hindu Succession Act 2005, which was came into effect on 9/9/2005, has retrospective effect. This is the stand taken by the Supreme Court of India. According to this judgment, even the daughters born before 2005, even their right was ignored by their brothers and other co-parceners, are also revived through this judgment. Now they can file the partition suit, or their legal heirs. If the daughter is deceased, even her legal heirs can file a suit against their grandfathers and maternal uncles and maternal sisters. This is the stand taken by Supreme Court through this latest judgment. Now the daughters have equal rights on par with the sons, irrespective of any cutoff date, any date which is fixed as a boundary or Lakshmana Rekha. Now we need to consider some other points in relation to the concept of inheritance rights of Hindu women. If during the lifetime of the first wife, the husband remarries without a divorce, the second marriage will be considered void. It is the well-known principle as per Hindu Marriage Act 1955. But the second wife is not entitled to write the inheritance over the estate of her husband. This is the rule we need to remember with regard to the inheritance rights of second wife if she was married by her husband without getting a divorce from his first wife. Second wife will not inherit anything, and the rights of the first wife will not be affected. But the children from the second marriage will get the share along with the other legal heirs of the first one. This is the stand with regard to the inheritance rights of the second wife or the second marriage. This is the effect of second marriage as per Hindu laws. Friends, this is the evolution of the concept of inheritance rights of Hindu woman as per Hindu laws. Says about the traditional laws. According to traditional Hindu laws, Shastras, Mitakshara school and Dayabhaga school, there is no right for a Hindu woman. According to Succession Act 1956, daughters have no right to inherit the estate of their father. According to amendment of 2005, if the daughter has a right to inherit the property of her father on the basis of certain conditions, the condition is the father as well as daughter should be alive as on the date of 9/9/2020. The next one is decided in Prakash versus Pulavati case. Thereafter, in Dhanamma's case, finally in the Rakesh Sharma's case, Vinita Sharma versus Rakesh Sharma's case. Now, we need to study the entire judgment of Vinita Sharma versus Rakesh Sharma in order to know the complete view on the Hindu Succession Act and evolution of the concept of inheritance rights of Hindu women. Friends, this is my first part. I don't want to focus more and more on the Hindu Succession Act 1956 and so on. My concept is very clear with regard to the inheritance rights of women as per the latest judgment, as per the up-to-date judgments of the apex court of our judgment. The second part is related to the inheritance rights of Muslim women. Friends, in the inheritance of Islamic laws, there is no such concept of evolution. From the beginning of the Islam till today, the Shariat law with regard to succession or the inheritance rights of Hindu women is very fixed. It is very standard and crystal clear. There is no such evolution as per inheritance laws of Islam. According to Muslim succession, there are three stages in inheritance. Stage 1 is deduct something. Stage 2 is allocate something. Stage 3, if there are no persons to allocate, go to the government under the doctrine of escheat. Coming to the first stage, deduct something. Sections 320 to 325 of Indian Succession Act 1925 are purely related to Islamic law of inheritance. This is the stage 1. According to this stage, deduct something. Now let us know what is to be deducted according to stage 1. The first one is funeral expenses and deathbed charges should be deducted from the deceased Muslim woman's estate. The expenses incurred for her funerals, the expenses incurred for curing when she was in deathbed should be deducted from her estate. After deducting these funeral expenses and deathbed charges, her debts to the creditor should be deducted. This is the second head under stage 1 of Islamic law of inheritance. After deducting the debts to the creditors, the wages, the salaries to the labor, domestic servants, artisan should be deducted from the estate of the deceased Muslim woman. And if she dies after making a will, as per the Muslim law, we know that a Muslim person, irrespective of his gender, whether he is a male or female, he has a right to alienate the property by way of will not exceeding 1/3 of the estate. Up to 1/3 share in her estate, she can alienate the property in the name of will. If she wants to alienate the property to her own legal heirs, the other legal heirs must give the consent to such will made by the Muslim woman as per Islamic law of inheritance. And the expenses incurred for obtaining the succession certificate, letters of administration, if she died after making a power of attorney, the expenses incurred for such power of attorney, etc., should be deducted. This is stage 1. Deduct something is stage 1. After the demise of a Muslim woman, these expenses should be deducted from her estate. Thereafter, there is some remainder in her estate. That remainder should be shared among her legal heirs. According to Hindu law, Hindu Succession Act 1956, there are 4 classes of legal heirs. They are class 1 heirs, class 2 heirs, nates, and cognates. But according to Islamic law of inheritance, there are just 3 classes of legal heirs. They are the sharers, the residuaries, and disturbed kindred. The sharers are also known as Quranic heirs. Why? Because the Quran, the holy book of Muslims, Quran itself states the fixed shares of the legal heirs. if there are no sharers, if the fixed share is distributed among the sharers, the rest of the property, the rest of the estate of the deceased Muslim woman will go to the residuaries. They are also known as the agnate legal heads. If there are no sharers and no residuaries, then the estate of the deceased Muslim woman will go to the distant kindred, who are also known as uterine heirs. If there are no sharers, no residuaries, and no distant kindred, then the entire estate of the deceased Muslim woman will go to the government under the doctrine of estate. This is stage 3, friends. Next, friends, as we know, the Islamic law of inheritance or inheritance law of Islam with relation to woman is very crystal clear, very crystal clear. After the demise of the husband, wife is entitled 1/8 share of her husband. 1/8 share, it is fixed. If there are no children, 1/4 share, it is also fixed. The Quranic heads, or the first class legal heads unofficially, include wife, mother, true grandmother, daughter, son's daughter, uterine sister, full sister, consanguine sister. Eight classes of legal heads are enumerated under Quranic heads. Just 4 in case of death of a female Muslim woman, her husband, her father, her true grandfather, and uterine brother. Just 4 classes are treated as the Quranic heads. Eight legal heads are treated as Quranic heads or class 1 legal heads according to Islamic law of inheritance. Just 4 male members are treated as sharers according to Islamic law of inheritance. Thus, the Islamic law of inheritance has given high priority for women. The daughters may inherit the rights of her father either as a sharer if there is no son, or a residuary in case of a son. This is the condition with regard to the daughter. Hence, I have not purely shared that daughters are the sharers, but there is no son. If there is no son, then the daughter becomes a sharer. She gets half of the share in the estate of her deceased father. Friends, mother's share is 1/6 share. If a Muslim man dies without making a will, even though after making a will, the remainder in the remaining property, that is in the remainder, 1/6 share goes to mother, 1/8 share goes to wife in case there are children. If there are no children, 1/4 share goes to the wife. If there are more than one wife, 1/4 share, a combined 1/4 share should be distributed among all the wives of the deceased Muslim man. The daughter gets half share if there is no son. If there are more than one daughters, all the daughters together will get 2/3 share. Then mother's mother, if there is no mother, then 1/6 share, which would have to go to mother, will go to mother's mother. If there is no father, then it goes to father's mother. Thus, the Islamic law of inheritance gave high priority for women. The shares are very fixed. It is very crystal. It is very crystal clear in Islamic traditional laws as well as the validation of Muslim Shariat Act 1937. You can go through the principles of Muhammadan law. Friends, is my video visible to you all?
Because
Hello?
you want to share it.
No, I want to show the book.
Book.
Sorry, sir.
How to give the sharing to you.
I want to continue. Okay, I would like to continue
Yeah, yeah,
the
yeah.
video.
Wind up, sir.
Okay. Thereafter, the son's daughters, if there is no son and daughter, then the son's daughter will get half of the share. If there are more than one son's daughters, then all of them shall get a combined share of 2/3 share in the estate of the deceased Muslim. Thus, the inheritance law, Islamic inheritance law, has given high priority for female, and the residue is also the full sister, consanguine sister, and the collaterals also have the right over the estate of a Muslim deceased person, irrespective of his gender. The distant kindreds include daughters, children, and their descendants, sons, daughters, children, and their descendants. Thus, it also includes more number of females in inheritance of Islamic law. Friends, this is the concept. Due to the time constraint, I don't want to say more and more about these two laws. Up to this judgment, up to 11/8/2020, the rights of the daughters in Hindu law are not treated as on par with the rights conferred to the sons, but the rights of a Muslim woman are standard. They are crystal clear since the beginning of the Islam. There is a fixed share for mother, there is a fixed share for daughter, there is a fixed share for wife and wives, there is a fixed share for mother's mother and father's mother, there is a fixed share for son's daughter or son's daughters. I would like to expect some queries from your side.
Thank you very much, Subhan Bande sir, for your extensively given for the both the comparison of the Hindu law as well as the Muslim law in the law of inheritance. Now I will give the chance for the at least 3 students to ask any question. The first come first served basis because the time is going to be wind up now. Only one you can unmute it and say your name, then ask your question.
Sir, I have a
Hello.
question, sir.
Say your name first, then ask the question.
Hello, sir. Myself, Amareshwar, second semester student of Mandir Law College. Sir, my query is, so there are laws like what the property, how it's distributed among sons or daughters or etc. But what if a father was found out he is in debt, means he is in debt of some other from some other source post partition, how this thing will be handled?
Okay, as per the traditional Hindu laws, the PS obligation is fixed only on the male descendants, the son's son, and their legal heirs, especially the male legal heirs, are responsible to pay the debts of the deceased Hindu. Now, as per the Hindu Succession Act 2005, as per the 9/9/2005 amendment, sons as well as daughters are entitled to get the assets of their father. In the same way, the son and daughter are equally responsible for the liabilities of their father.
I think the answer is given over there. Yes, the second student, say your name and you can ask because only 3 minutes are left. Yes, anyone can unmute it, then you can ask it. If there is no questions, then I can play the Janagana Mana.
One more clarity, sir.
Yes, please continue, sir.
If the partition, hello,
Yes,
may I
continue, sir.
know the name of the student? May I know the name of the student who posed this question?
Amareshwar.
Amareshwar.
Yes.
Mr. Amareshwar. Mr. Amareshwar.
Yes, sir. Yes, sir.
According to you, the legal heirs of a deceased Hindu man have filed a suit and they get partitioned their respective shares. Is it right? Is it right?
Once the partition has been done, no,
After
sir. My
getting
question was post-partition.
okay, partition has been done.
After partition has been done, there was a case, someone claiming
Okay.
that your father was in debit of me. So there was a debit came up.
Okay,
So what
after
will
partition
be,
has been done,
yes, sir, post-partition.
only the property possessed by the deceased person. Hello?
Yes, sir. Please
Only the
continue, sir.
property, only the estate of the deceased person is liable for the execution. For instance, the partition has been done. The sons and daughters have got their respective shares. At the time of, hello?
Yes, sir.
At the
Please
time of
continue.
at the time of their father, then their father has also got some share as per that partition. Then the share which he possessed at the time of the death is only liable for execution. The decree holders may file an execution petition. They may attach the property which is in the name of the deceased Hindu person. They can sell the property and finally recover their debts. They cannot go to the properties of the sons and daughters. Partition has been done. The sons have got their respective shares. The daughters have got their respective shares. Only the property still remained in the name of the deceased Hindu is liable for the execution. This is the rule.
Okay, thank you very much, sir. That now the time is up, and this
Any other
time,
question?
yes, sir. Because I gave the chance, but nobody is making out. Anyway, the time is going to be up now, and by the end of this thing, that I would play this national anthem so that we can wind up. Thank you very much, sir, for your valuable things, which I got it over there. Yes.
जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड़ उत्कल बंगा विंध्य हिमाचल यमुना गंगा उज्जल जगति तरंगा